because the guidance is just that, guidance. I'm giving you direction on where you need to go and how you need to get there. Now, when we're sitting here and we're going through this, I'm going to get into part 2, but understand, anything I give you, the free is Spotify, the free is iHeartRadio, the free is YouTube. Because even those on Patreon, they're paying for it. And if you want more, there are 3 tiers that you can go to on YouTube. There are 3 tiers that you can go to on Patreon that offer you other aspects of this. Because not knowing your value is a dangerous thing. Because again, whenever it gets hard, whenever they're saying things to you that's going to be discouraging for you to actually quit and not move forward and to not do the things that's necessary for you to become successful at it, it becomes something different. I want you to understand, it becomes something different because now you're moving with expectation. So when you lose a battle, it's okay because you're expecting to win the war. When you stumble here, when they misdirect you there, you understand that the war is your goal. There will be casualties. And even like Jigsaw, there will be blood. You will have to become a monster at some point. But it's the managing of your expectations is what's most important. Now, the reason why we're going into discovery and this at this depth or whatever is the understanding of simplicity. Because everything we're doing, we need to be direct and simple. The first part of the direction is putting it in writing, being very detailed in what we're looking for. Also understanding what it is they cannot do, and if they are doing it, how they must do it. So I'm going to cover a couple of things in here. I'm going to finish going through discovery, but I'm also going to give you a couple of the counters that they may use and how to take those away. Because just like I told you, at this point, some point this year, we're going to start working on a new series, which is called Weaponizing Your Defense. And it's simple because the things I give you, it's how you confront your witnesses against you. Discovery is a key point in confronting the witnesses against you. Because even one of the 3 or 4 possibles, because I've given you 3, but depending on your matter, on how it's going to be structured, or if it is structured, those 3 at all, I give you a possible. And the one thing I love about it is codified. And I think I found it in 15 states that I've actually worked in and looked in. Louisiana being one, Georgia being another, Texas being a third, North Carolina, I think 4th. So they're in these places, California, but it's called the revocation of presumptions. So you revoke presumptions, which means now they cannot assume any evidence. And any right you're choosing to exercise must be done in writing. See, I gave you a Supreme Court case on that. I want you to understand. I gave you a Supreme Court case on that because even when you say, I don't want these Supreme Court cases anymore, you must still understand how they apply and why I'm giving them to you. I'm starting using repetition on that because I'm making sure it sticks. These are the things that are, what's the word? These are the things that are necessary for you to learn and grow. Because that's what we're about this year. We're going to go into improving not only the quality of our videos, we're going to go into improving the quality of our podcast. We're going to improve and grow, because even looking to get on Roku or be on Roku by May of 2022 and making sure our channels are connected and the things that we're doing are put to a point of expected or expanded growth. And we want to also, again, thank Spotify for these opportunities that they're offering for us. So, went through this thing called Strickler v. Green. Green gave you 3 essential components of a Brady claim. Brady is simple, because I'm actually going to read it. Brady v. Maryland, 373 U.S. 83, 1963. Now, when does a Brady violation occur? It's when the withholding of evidence violates due process. And a lot of times that's what happens with a prosecutor, because you'll do your discovery motion. They have 10 days to turn it over. It's codified not only in most states, it's codified in the federal rules of criminal procedure, as well as the states' rules for criminal procedure. Some states offer about 14, but you also, in the midst of that 14, they're counting weekends. So it kind of balances out, because in 10 days, you're going to get 14 days, which is 2 weeks. But the key part is whether you ask for it or not. Why? Because that's part of due process. So when that doesn't happen, the prosecutor who's cherry picking this case, they become liable for that evidence simply because that's what they have to present to the jury. And if the prosecutor suppresses evidence favorable to the accused, it violates due process as guaranteed by the 14th Amendment of the United States Constitution. And Brady is violated when the government fails to turn over evidence that is known only to police investigators and not the prosecutor. And that comes from Youngblood v. West Virginia. And it's a 2006 case. Now, why was that important? Because I've said this 1,000 times. But the case, most people were not very familiar with, because while it's a case that set precedent on one part, it's actually a case just like Terry v. Ohio. There are several cases that fall under it. Just like Miranda v. Arizona, there are several cases that fall under it, because law is not emotional, it's situational. Because in different aspects of Terry v. Ohio attaches to different aspects of a police encounter. Every stop does not trigger the same encounter or response. Terry v. Ohio doesn't cover every aspect of that. So there are other parts that cover that. And the Brady v. Maryland, Youngblood is one. Strickler v. Green is a second one. Now, what happens is 3 essential components of a Brady claim are evidence favorable to defendant because it's exculpatory or impeaching. Now, when I did the video, the podcast about Giglio, police character on trial, that is part of impeaching. Now, when we talk about the state willfully or inadvertently suppress the evidence, that's where Youngblood comes in. Youngblood is whether it's known by police known by the prosecutor or not. If it's just the police that have it, they're still responsible for it. Because even if there's something done that will prejudice the result or prejudice resulted from it, that's where the revoking of presumptions come in. Because, give you an example, oftentimes we see things, and the easy part of it is most of us bear little weight to it. The example I'm going to use is Derek Chauvin. He was on trial for the murder of George Floyd. While they're picking the jurors, there was a settlement announcement on every news location broadcaster across this country. Everybody that wanted to talk about it talked about it, and there was no way he could get a fair trial. Why? Because the verdict was against the city for the actions of Derek Chauvin, which is also the reason why he had grounds for an appeal. So when he was convicted, he then took a plea for the hate crime statute in federal court, because again, not only did he violate state law and state procedures whenever he did his action, but he violated federal. But the most important part was he didn't receive a fair trial because of prejudice resulted from the actions of the announcement during voir dire. So that violated his due process, which then can be used in terms of legal error. Now, I had a question that was brought to me. Question: does Brady mean we have to disclose evidence that does not show the defendant to be innocent, but merely cast doubt on the testimony of the prosecuting witness? Now, that is a phenomenal question. We don't have to show that the defendant is innocent. Now, during a trial, the jurors like to hear that, because it's when you humanize someone. And again, I hope you're paying attention, because this is weaponizing. When you're going through a trial and you're humanizing someone, I think that was kind of adequate for the birds at that moment. But when you're humanizing someone, it's more difficult for people to actually hold them to punishment. But by merely casting doubt on the testimony, which is the impeachment of even the officer, because one lie can destroy 100 truths, and the casting of doubt, because remember, you have to be guilty within a reasonable doubt, beyond a reasonable doubt. Goodness, I can't speak today. You have to be found guilty beyond a reasonable doubt. Now, what happens? As part of the painting of the picture. Now, we often use that as perjury. These are the reasons why I tell people to get, or you're going to request in your discovery, the unaltered communications of the police officers. That will be video and audio. A lot of times you're not going to get that. But one thing you cannot be denied is the warrant application for the search warrant or arrest warrant. The reason why you can't do that, because it's sworn to under penalty of perjury. And also the police report. Oftentimes it's called a scene report, because if perjury is committed under oath, or the terms untruthfulness refers to a false statement, false reports, or intentionally incomplete statements, the reports involve all aspects of the job, not just enforcement or criminal allegations. The reason why those are is because you're casting doubt. You're painting a picture. That's your brush on what's being said against you. You're as most people say, you're creating the doubt that they're being truthful. Because you can have other things such as the letter, even bias, because even if you have certain things, so I'm gonna give you two examples on this one. During my trial, Judge Courtney Johnson, to me, she allowed things that we actually submitted in writing into the trial that shouldn't have been there. She allowed the trial to go on without evidence. There was a lot of lacking evidence. Like most of the stuff was speculation or circumstantial. None of it was concrete, and it didn't point to a specific person. And the things they had weren't even illegal. However, they referred to them as being illegal, yet on cross there were certain things that was not allowed or objected to that she agreed with the objection. So having us sign documents throughout the trial or whatever, I was asked to stand up because we did sign one, and we signed it, and she didn't like the way it was signed. So she asked, well, what does this mean? I sat first chair, so I stood up, and I think that was fold and tuck day. One of the things I pointed out was her bias that she had interjected into the trial. Why did I use the word bias? Because words have power. There's a court stenographer that's there that is recording everything that's being said. I use the word bias because bias has power. Bias is grounds for appeal. Bias is also grounds for throwing that shit out. So I used it because the look of impartiality offers me a way to get home. I weaponized the word bias. Michelle Odenit, Judge Michelle Odenit in Louisiana, she used the N-word with impunity. Come to find out, she stated that the night that the incident happened, she was inebriated. Well, the problem is, come to find out, the video was taken a couple of nights later. And she probably still was inebriated. And it was taken by someone in her home. Well, she used the N-word several times. Multiple people in her family, her husband, used the N-word several times. Now, her cases as not only a judge, but those that she handled as a prosecutor that dealt with people that she referred to as roaches are now called into question. Why? Because there's an attempt to search for legal bias. Because now those people can be exonerated. Or, as they did in New York, offer them a couple of dollars just so you can save the city millions. I'm going to say that again. The reason why they do that is to save the city millions. Because it's about revenue, it's not about crimes. Now, most of us think, okay, if I turn over a false report or there's bias, there's some sort of crime that is being committed. Crimes committed by officers, which must be disclosed, including any crime other than motor vehicle misdemeanors or DUIs. Motor vehicle offenses must be disclosed to the prosecutor when the criminal cases involve similar conduct. Why is that? Because that goes to the impeachment when we're confronting. These are questions that we may not ask in the original discovery, but these are things that are now open when we see the officer's name on the witness list. We can go into personnel records that deal with specificity of that act, not all of the officer's personnel information. We can go on complaints filed against that officer. But again, we have to give time, date. A lot of times it's going into sex and locations. Those are things that can offer those opportunities for impeachment. But it requires an idea of wanting to confront someone, but it also details the fact that you must be committed in fighting. Because here's where I actually want to really get into today. Is because why can I not have this stuff organized like I want to? Okay. And I still don't. When we're looking at this, there's a requirement for disclosure, and it's called the Open Government Act and the Freedom of Information Act of 1966. There's this thing called Vaughn v. Rosen. It's a 1977 case. A 1974 case. That one of the things I tell people to use, simple, because words have power, is I'm requesting my own records. Because a lot of times you have to understand what these acts are, and you have to understand what these Supreme Court cases are for. Because there's an allowance for the prosecutor not to turn over information. I'm going to go into those individually, but because again, you have to understand context. You have to be able to, as a few of my people I've heard, overstand it to actually execute it. Because now you'll stop asking certain questions. And one of those is no record being requested is related to the national defense. Many of you have heard me say that before. Because at the end of the day, we have to put together a fair and proper defense. If you have an attorney representing you, The defense attorney must put on a vigorous defense. Part of that vigorousness is a detailed discovery. And it's amazing because when Tommy Sotomayor said the defense doesn't defend, I have only seen out of literal thousands, maybe 2 that were detailed from a defense attorney. Both of these attorneys are on retainer for more than $50,000 per month. I'm gonna say that one more time. I've only seen it from 2. And the 2 attorneys that I've seen it from are on retainer from their clients for more than $50,000 per month. Now, you do the math, what that is per year. They're getting paid $600,000 a year just as a retainer, just in case shit. A $50,000 retainer is an insurance policy, just in case shit. But anybody else, I have yet to see it from. 2, the record is solely related to no record is solely related to internal personnel rules and practices. Now, here's the catch-22 on that one. Because you do realize the Freedom of Information Act requires or authorizes you to have the ability to get personnel rules and practices. The reason you use this record is not solely related to. It's simply because your painting is one of your brushes. Even if you ask for personnel or department policy, it's only relating to part of your defense. It's not your defense in its entirety. It's just a part of it. No record is directly accusing anyone of a crime. Now, we're not saying that a crime will not result from the request that we're having. We're just saying that it's not directly accusing anyone. Why is that important? Because if you're solely going after someone, you are now the accuser. The defense does not have to prove anything. I'm going to say that again. The reason that no record is directly accusing anyone of a crime is because once you become the accuser, the defense does not have to prove anything. You do. They are not required to turn over information that you are accusing them of doing something. Part of their defense is shutting up. You prove it. Yet when it's our turn, we want to explain. And then we get convicted without proof. I'm going to say that they shut up. We give everything else to explain. Now, I'm going to give you a conversation I had this morning that I actually thought was hilarious afterwards. I had a friend of mine sent me some information they wanted me to overlook because they was getting ready to fight their court case. First thing they did that I hate, sent me an affidavit. 13 pages. And I sat down and they're like, well, what's the problem? And I asked, why do you feel the need to explain anything? He said, well, why don't you? I said, because I'm an adult. I said, what does that mean? I said, when I was a child, I behaved as a child. As an adult, I put away childish things. I don't need to explain anything to you. One of the rules from Art of War is the simple act of saying less than necessary. Become a good storyteller because you have to leave people with that cliffhanger. They got to want more. Leave them wanting more. If you give them everything, guess what? You get information overload. Because it amazes me. I've been doing this for 3 years now, and everybody's like, give me more, give me more. But then they're saying, what else? What else? they're hanging on to the words. They're hanging on to the videos. They're hanging on to these things. Because if I gave you everything at once, your stomach get full and you'll stop watching. No point in it. But if I give it to you a spoonful at a time, keep wanting more. That's where this comes in at. Because you have to understand, and I also tell people one thing you have to do is, as an adult, quit explaining yourself. You're the defense. You're not the accused. You're the defense. Shut up. You have the right to remain silent. Most of us don't have the ability. That's the problem. That itself is the problem. Because we feel it necessary that we got to let them know why we did it. Nobody gives a shit. I mean, that's the plainest English of all. Nobody cares. 90% of people don't care you have a problem. 10% of people probably gave you the problem and they're happy you have it. So if I look at everybody that's in the courtroom, judge, prosecutor, defense, all of them have bar cards. All of them are eating because you have a problem. Then you have the jury. They're somewhere they don't want to be, doing something they don't want to do, listening to something they could care less about. There's 12 of them and 3 of those other people. That sounds like 90-10. So out of 15 people, only 3 people actually happy that you have that issue because they're eating. Your issue is allowing them to eat. The other people there don't want to be there. They give a shit. But you want to explain to people that don't want to listen to you what the problem is. Now, no record is information where disclosure would breach the privacy because these records are requested are of public records. Now, here's the flip side of that, because most people don't understand. I actually understood the context of the words have power. Had a young lady that I was dealing with, and hell, in fact, it's funny because she wasn't the only one. There have been multiple young people that I deal with that I've been helping out that couldn't understand the difference between personal records and personnel records. Say that one more time. Personal records and personnel records. Personnel records deals with someone's employment record. That doesn't. Personal records deal with their social security, phone number, and their home address. Some of those things you can't use. Some of those things are part of the requirement. So understand the difference between personal records, social security, birth certificates, things of that nature. Those are personal because you have the right to be private in your person and property. And personnel, which would deal with department issued stuff and things of that nature. And no record will harm or delay the proceedings. Now, I'm going to give you a little kick in. In fact, could prove to speed this matter along to a conclusion where the absent would serve to prolong them. Why is that statement so huge? They'll tell you, we don't want to keep putting this off. We don't want to keep putting this off. I found, even if you watch the video that actually dropped on New Year's, you'll find the beauty in that statement. Because when you inconvenience those who are cherry picking your case, it ain't no fun when the rabbit got a gun. Because they will delay. I actually watched them. This young man sat in jail 3 years because he couldn't afford bail for a crime he did not commit, and the officer made up. I'm gonna say that one more time. Young man sat in jail for 3 years for a crime he didn't commit and the officer made up. He said it to his attorney multiple times. He said it to the prosecutor. He even said it to the judge. The judge said, well, you don't have any proof of it, so it's on you. But you know what his defense never did? Stop allowing continuances. Because most people don't understand the right to a speedy trial is 72 days. 90 because it goes to a quarter. But you also have to remember, in those 90 days, which is 3 months, you can't count weekends and holidays. 72 days. What can happen in 72? There's a lot that can happen in 72 days. Because most of us are living paycheck to paycheck. One paycheck throws us all the way off. Miss one paycheck, we're completely underwater. But they'll do that just as simple as they actually did with John Jones, who's actually a millionaire. And it was done so he could not get paid again. Because you can't get licensed when you have a court case, an open court case. Matter of fact, in his case, a felony court case at the time. So now they were choosing to inconvenience John by, oh, we're going to continue. It went from October to January. It amazed me because, again, the war is on the poor and the undoctrinated. Now, last year, 2022, around the middle to end of October, most people that had November court dates got pushed all the way to February 2022. Why is that? That's more than 90 days. One, they did not have a case against them. They didn't have evidence. But they're hoping to inconvenience these people. They're buying themselves time because they're trying to strategically wait you out, inconvenience you, because now not only do you have to come in November to find out that you're coming back in February, they may postpone it again, depending on how ready you are. And this is actually one of the things, I actually did one where they talked about that the prosecutors were lobbying against the defense having the ability to continue or prolong cases and basically weaponize the defense. And I thought it was hilarious simply because the prosecutor was protesting against allowing tactics that the prosecution uses. Isn't that funny? They did not want the defense to be able to use the things that they use to inconvenience people. Yet, they want to continue doing it and don't want any reprimanding from it. To me, that is one of the most hilarious things I've ever seen in my life. And lastly, no record will lead to financial speculation or endangerment of the stability of any lawful financial institution. Why is that important? Because in this case, most cases, when you're violated by due process, the prosecutor is now liable, as well as the police officers that are involved. One of the things that you hear about is wrongful arrest. Part of that will come from a detailed discovery request. Those records or lack of records offer, because remember, even if the police don't turn it over, the prosecutor is liable for those records. If you've requested them, they have a duty to turn it over. But you must learn how to exercise in writing. And every time you do that, you must now understand what your level of justice is going to be. So, in conclusion, you must be ready to not only fight, you must be ready to go to war. You have the opportunity to decide what the fight is worth to you, what the right is worth to you. Because any right that someone won't fight for, when you give up one, you give up them all. It's the art of the negotiation. Are you going to excuse their behavior, or are you going to hold them accountable for it? Are you going to put it in writing and enforce the fact that they must turn this over? And start telling them, yeah, we're not going to continue taking this. Because now when you're talking about those institutions, you're talking about going after a prosecutor for their livelihood, going after a prosecutor for malicious prosecution. Because continue to do something that violates someone's due process rights when they are the ones that are there to protect truth is malicious. Not only is the DA's office culpable, because just like I spoke about, you can go after the supervisors. You are the overseers. You're responsible for your employees. Just like they tell parents, you're responsible for the actions of your children. A supervisor is responsible for the actions of their subordinates. The DA rarely takes on a case, leaves that up to the subordinates. When you start going after them, it's not solely for the endangerment of a lawful financial institution. When they're acting unlawfully, that's the loophole in that statement. The actions of the DA's office was unlawful. The actions of the police department and that police officer was unlawful because they are required by law to enforce law, not statutes, codes, and ordinances. So when we're talking about these things, it becomes something different. So we have to understand that words have power. Actions are shown through the pen. Keep that in mind as we go along this journey. I love you guys. There's going to be a lot of new stuff popping up over the next 2 weeks. And I'm going to look for you guys to continue to support as we keep going, keep growing. I love you guys. Supreme Decisions, out.